The next stage that we're going to consider in the development of your business proposal is stage 6, the legal considerations. Um, One of the difficulties with this course is that um, when you get to the pro forma balance sheet, income statement, and cash flow, you should really have had a whole course with a whole textbook to really understand and do that. And then the other problem is that when you get to the legal considerations, um, the author does a really good job in sort of outlining them. I think he oversteps his bounds when he starts telling you how to do things like how to file a trademark application, but I'll come back to that. The difficulty here is, of course, that the stage 6 legal considerations in this textbook uh, can only be superficial because in BADM 107 we have this textbook that thick that covers legal considerations in or in businesses. So those limitations have to be taken into account, and I guess one of the difficulties is that if an accountant was teaching this course, the pro forma balance sheet and income statement and cash flow material would expand, and I'm trying to remember that not to expand the legal considerations too much either, but there are limits on that. All right, so here we go. Slide 83 deals with risk management. And in fact, all lawyers do is deal with risk management. There is a movement in the law profession to trying to be proactive in preventing problems with clients rather than solving them after the clients have made the mistake of falling into the pitfall. Risk management involves 4 things. You won't find this in the textbook, but this is in the law course, and I'm putting it in here because it's very, very practical. Eliminating risk, reducing risk, shifting risk, and retaining risk. A risk is defined as a possibility of loss or injury or a danger of element or factor. The third definition that's on that slide is a chance of loss or perils to the subject matter, and that's really deals with insurance. Okay, so eliminating risk, a good example of that, as I've already talked in the previous stage, is the preparation of a business plan, which will tell you whether or not you should go ahead or whether or not you should not go into a certain venture. Reducing risk is attention to HR management conditions so that you handle employees correctly and don't fire them and get sued. Quality control measures in the preparation of products and services. And then judgment proofing your assets to the best of your ability. Things you can do to shift the risk is to incorporate a company so that all the business is with the company, not you personally, and so it's the corporation that gets sued, not you, or shifting the risk by shifting the liability to an insurance company. The thing you have to remember about that is you can get a billion dollars worth of insurance, and it's not going to prevent something from happening. All it does is it shifts the risk away from you to the insurance company. And then finally, it's retaining the risk. At some point you say, okay, there are risk factors involved in this, but I can reduce some and I can shift some, but I can't eliminate them unless I decide not to do the venture. And so that means you retain some portion of risk, and that's what entrepreneurs do. The book starts off by talking about the forms of business organization. So when you establish your business, you have to establish it in one of the 3 basic forms. There was one management textbook that actually listed 14 different business forms of business organization, and all he was doing was saying that there's employee-owned corporations, there's private corporations, public corporations, there's wholly owned subsidiaries, and really there's only corporations, okay, and the rest are just subcategories. And partnerships, he said, oh, there's partnerships, there's general partnerships, limited partnerships, and limited liability partnerships. Oh, there's 4. No, they're all the same. They're partnerships, okay, they're just subcategories. However, there are other 2 categories of business organizations which take on some sort of business characteristics. Societies like the Chamber of Commerce, for example, or nonprofit organizations like the Board of Trade, or cooperatives like the Mountain Co-op and places like that, just structured differently. All right. So, sole proprietorship is an unincorporated business owned by one person who has unlimited liability for all the debts and obligations. And so if I had a sole proprietorship and I got sued for $11 million and the proprietorship was only worth $80,000, what happens to all the money that I can't pay off? Well, they come back and they go after my house, my cottage, my investment lot, my cars, my sailboat, and my casa in Mexico, probably my eldest children. I'm just kidding. Anyway, that's the problem with sole proprietorships. We can see that the advantages are simplicity, personal control, fewer regulatory requirements, tax advantages initially, anyway, profit retention. If you make a profit, it's all yours, and ease of dissolution. You want to stop, you just, stop, right? But the big disadvantage, of course, is your unlimited liability situation. You can do something to alleviate that. It's becoming more and more difficult, but you should attempt to do this, and you only do it with a lawyer. Okay, you do not do it yourself, and that is you transfer your assets to your spouse or your significant other. You have to be in a stable relationship, otherwise this can go awry. But when I got called to the bar and I could now become a practicing lawyer, I talked about the risks involved in being a lawyer, and so what I did was I transferred all my assets into my spouse's name, and so she owned the house, she owned the cars, and she owned the sailboat. If I got sued and my $1 million worth of insurance wasn't sufficient to pay it off, they cannot come and take my sailboat. I don't have a sailboat. My wife has a sailboat. I sail on it, okay, but it's not mine. So you can do that, but it's extremely difficult. It has to be done properly, and so in a book like this, it's a legal consideration, but there's no way that the authors should talk about it. If they mention it in passing, then what that means is go and see a lawyer. Okay. All right. So there's advantages. The disadvantages, as I said, unlimited liability, lack of managerial support unless you hire people. Okay, and then there's a cost to that. Taxation. How can taxation be an advantage and a disadvantage? Well, when you establish your business, there's write-offs. And all those write-offs can be deducted from your taxes. But after you get operating and you start making more and more money and you're very profitable, the government comes along and will start taking 50% of everything you make. Difficult to raise capital. To a certain extent, it is more difficult because banks think if you're a sole proprietorship, you look and may appear to be less professional. And so they're a little leery about your operation. And the other thing is there's just your personal assets for the business. But if you're in a partnership or a corporation, then there's other people involved with you who bring in assets. Succession uncertainty, that's the transfer of your business either when you retire or you pass away. And so this brings into play things like wills and powers of attorney, and we'll get into that a little later on. But right now, succession uncertainty, what's that mean? I have one fellow who runs a textbook ordering and selling business, and he's making money hands over fist. But it's his business. He has people working for him, but if anything happened to him, those people wouldn't know what to do. So it would close down, and the business would be sold for its assets only, which would not be significant. It was really the ability to make money through the business that really made it valuable. And so if he was to pass away without a succession plan, then that would be a definite disadvantage. So what you do to eliminate that, of course, or at least reduce the risk, is you very quickly establish a succession plan. Fortunately for him, he has some children, and one of his children is really, really interested in the business. So my client's former client's succession plan was to give the business to the one son and then divide up the other assets that he owns so that it's equal and give those to his other son and his other daughter. That doesn't always work. The client up north that I talk about is facing a situation where he has two sons, and the hope was that they would take over the business. One of them is really keen about it. The other is a bit of a flake, I guess is the best way to look at it. He doesn't realize that in a family business like that, you don't have a 9-to-5 job. And so his attitude was, well, I want to start at 9 and quit at 9, but my client has to fly to a lake and pick up some fishermen. Well, you don't say, oh, 5 o'clock, sorry, can't pick them up today. They're going to have to pay extra because they'll be staying there a day longer. No, you just do the work when it has to be done. And the one son doesn't want to do that. It's a seasonal business, and so he said, well, I want to start at the beginning of June. Yeah, I know you go up there at the beginning of May and do a month's worth of preparation, but I don't want to. I just want to start at June because I want to visit my girlfriend in Vancouver. And that isn't how managers work. Managers work when there's work to be done, okay? Family business, you do the work when the work's to be done. You can't just say, oh, it's 9 to 5, see you later, I'm done for the day. So they have a problem now that one son wants to take over and the other wants to, be paid out, which is really difficult. There was one other example too, but it didn't come to me right now. So, yes, I have one other client who has a very profitable operation, and he has two people that have been running it, and he's basically been taking less and less involvement and sort of fading out of the picture. Now he wants to settle everything up before anything happens to him. And he thought, well, those two people that are running the business, a mother and a son, are phenomenal. They're going to take it over. And so he started talking to them, and the mother said, well, yes, gee, thanks a lot, but I'm sort of older too, and I want to phase out my involvement and be less involved and eventually leave and retire. And the other fellow said, oh, well, okay, sure, I'll run the business, but I need some support from my mother. So they're working out some sort of scenario, and now I can't help them because I'm not a practicing lawyer, but the shares will go to the mother and the son equally, and then the mother will slowly transfer the shares to the son and will provide managerial advice until she no longer wants to or until he no longer needs it. All right, partnerships defined by the Partnership Act, which is a statute. If you have a partnership, you are governed by the statute unless you take some steps to create a partnership agreement, in which case there are things that you can do contrary to the statute. All right, so it's two or more people working in concert with a view to profit. That's pretty much the definition in the Partnership Act itself. So then there are general partnerships where, I'll use the example of a three-man partnership because I was in one. You all have liability together, okay? There's no separation of the business from your personal assets, just like in a sole proprietorship. The only difference is potential liability is divided amongst the number of partners, or the potential profit is divided up amongst the number of partners. Then there's limited partnerships where you have a general partner or maybe two general partners or 462,000 general partners, and somebody wants to invest money but they don't want to become a partner and jointly and severally liable. So they can invest almost like buying shares. Okay, but you invest a certain amount of money and you get deemed to be a limited partner, and your losses are limited to the amount of money that you put into the firm. And then the textbook talks about limited liability partnerships. You have to be a little careful here because he's an Ontario author, and it's Ontario law that he talks about. So on page 163 of the textbook, the author makes passing references to limited liability partnerships because they're only used by law firms and some accounting firms in Ontario, and no one else is allowed. Well, in British Columbia, anybody can establish a limited liability partnership. How does it work? If I'm in a partnership with two other partners, and one of those partners is negligent, all three of us are responsible for that mistake. So it's almost worse than a sole proprietorship, because in a sole proprietorship, I'm responsible for any mistake I make. And that's okay to me because I have control. But if I'm in a partnership with some other people, I no longer have as much control over that other person. And so if they make a mistake, and there's more likelihood that one of the partners will make a mistake just by odds, then I'm responsible for that person's negligence. Well, that's worse. Okay? So you can set up this limited liability partnerships where if one partner makes a negligent mistake, they are solely responsible. The person that's suing cannot go through that partner and take my assets. That's of benefit to law firms. The difficulty with that is, even in our small three-man partnership, we had one legal secretary, and one legal assistant, and one associate. And so if any one of those are negligent, the limited liability partnership doesn't stop us from being liable for them. Okay. Now, I'm not liable for Bob Mackay, and I'm not liable for Lance Turlock, but if any one of our employees makes a mistake, it's because we didn't oversee their work closely enough, and so we become jointly and severally liable. So there's no limit on who can be a partner, limited liability partner in BC. It's different in BC than anywhere in North America. All the states and Ontario and the other Canadian provinces all have limits on who can, all have restrictions on who can become limited liability partnerships. In BC, anybody can. Okay? Okay. Advantages of partners. You pool wisdom and knowledge. Okay, two heads are better than one, three are better than that. You pool financial and physical resources. So I get together because I have some gardening tools. A fellow has a truck. Another fellow has some wheelbarrows and a little backhoe, one of those bobcats. The three of us get together and we pool those assets, and we pool our money. Okay, and so we have pooling of financial and physical resources and our wisdom and knowledge, and it's just it means there's a better possibility of being successful. Simplicity and ease of organization, that's often cited as an advantage. You have to be careful here because I don't believe in it, which is why on screen 69, there's a big X beside that. When you establish a partnership, you have to register the partnership, and there's required information that has to be filed. More information has to be filed if you have a limited partnership or a limited liability partnership. Not as much as a corporation, but pretty close, okay? And if you have a partnership, you should have a partnership agreement. So it's not as easy as the textbook would suggest in setting up. Potential for growth. I think the potential for growth is either the same as pooling wisdom and knowledge and financial and physical resources, or it's not true. The potential for growth depends upon your idea and the market that you're serving. Okay? Your sole proprietorship can grow phenomenally, just like a partnership. The fact that there's two people in a partnership doesn't make it any more likely that your market will grow or your product will be successful, except for the first two advantages. So a big X beside that one. Disadvantages, I think the disadvantages far outweigh the advantages in partnerships, and I would have to caution people when they are going into business with friends, relatives, or business associates to look at the possibility of a corporate scenario and listen to your accountant, because it might be financially advisable to do a partnership, or from a liability standpoint, it might not be advisable. Okay? And the first thing you have to realize is that partners are jointly liable for all the debts. So the firm owns $80,000, and there's two of us. We're each on the hook for 40 grand. If one of the partners is negligent and causes a $300,000 loss, and there's two partners, then that's $150,000 each, isn't it? No, joint and several liability. Okay, several means each of you are responsible for the total amount. So let's say my partner is negligent and causes a $300,000 loss, and he has structured his affairs so that he's judgment proof, which means his assets are owned by his spouse, or maybe he's hidden them offshore, which that would be unethical. Let's say his spouse owns all the assets. Well, they sue him, they don't get anything. Well, they sue me, they don't get $150,000. They would get $300,000 from me. So I am liable for not only my portionate share, but the whole amount. That's why partnerships are definitely worse than sole proprietorships and corporations. The need for group decisions can lead to a loss of valuable time. It's a lot harder to, if you had a lot of partners, like there was one downtown law firm, Russell and Dumoulin, that at one point had about 110 partners and only about 80 associates. A little bit top heavy there. Hard to get 110 lawyers together to make a decision. When you have two lawyers, you usually have three opinions, so that would be just total chaos. There's that problem. You can get rid of that to a certain degree by having a decision-making body, like a group of senior partners or something like that. But then it starts getting very complicated, like a corporation. Stalemates lead to ineffective inactivity. I discussed this quite a bit in 107. I'm going to go quicker here. We had three partners in the firm. I mentioned that my partnership exploded. That's because it was incredibly poorly managed. We had a manager, someone who was supposedly managing our firm, who could not manage anything. And we were not making as much money as we should have. And I was always constantly trying to have a change made. I wanted to fire that manager and hire another one. And the reason that we didn't was that manager was the wife of the senior partner's best friend. So there's the senior partner, he has a really good friend. His wife needed a job, so he said, you be the manager of our firm. What was her qualifications? Her qualifications were that she was the wife of his best friend. She had no management background, and she proved it. Okay, and so I wanted to fire her. The senior partner, of course, didn't want to fire her, but that's okay. There's three partners, so we have to have a decision, don't we? Finally, I'd had it, okay, and I called the other partner into the office with the senior partner, and I said, look, I want a decision right now. I want to fire her. And the senior partner said, I don't want to fire her. And the two of us looked at the third, who went, I don't care, and he ran out of the room. And I thought, just my luck that I'm in partnership with the only partner or only lawyer on the face of the planet Earth that doesn't thrive on confrontation. Okay. So 1 for firing, 1 against firing, and 1 abstention. What happens? Nothing. Okay. It's a deadlock. So ineffective activity, we struggled along. We were making money, but not very much. We were doing okay, but we weren't making anywhere near the amount we should have been. More difficult to change ownership? Well, it is in a sense, because if a partner leaves, you apparently now do not have to dissolve the partnership as a whole. You can register that one partner left and another came on board, or one partner left and nobody came on board. Didn't matter. You can do that, and that's not too much of a problem. But from an accounting standpoint, you still had to close down the books on one partnership and start up another. So it's more difficult than in a sole proprietorship. And then there's potential liability after dissolution. You can minimize this. Okay, you can reduce the risk of this. Pardon me, but if there's three of us working as partners and we dissolve the partnership, and one person has been working with one of the partners for years and years and years and years, and that partner screws up, that client might not know that the partnership has been dissolved, and so he's entitled to sue all three of us, even though we have broken up the partnership. So you have to register the dissolution of the partnership in Victoria. You have to send letters to all your clients and all your suppliers and as many former clients as you can remember, and you have to publish in the BC Gazette that the partnership is dissolved. So it gets a little more difficult. Limited partnership, there must be at least one general partner and then one limited partner, as I said. It's an advantage for raising capital, obviously, because you have this person that wants to invest. A disadvantage is the liability of the general partners remains the same, okay, but it's only the limited partner who is protected, and that's only if that limited partner does not get involved in management at all. Corporation, a separate legal entity, separate from the shareholders, and here's a heads up. If you are in a partnership, you would refer to your partner as, hey, this is my partner. If you are in a corporation and there are two of you that own shares, you never say, yes, here's my partner. Okay? The whole point of incorporating a company is to take advantage of limited liability, which is on slide 92. Okay? And if you say, yes, we have a corporation and here's my partner, the person that is suing you is going to be able to sue the corporation and each of you as partners because you held yourself out as being partners. Whether you are or not, doesn't matter. That person can sue you. Who would ever make this mistake? A fairly sophisticated business person worked in town and lived on the Sunshine Coast, just like I worked in town I lived on the Sunshine Coast and worked in town. I was coming home on the ferry one night, and this person cornered me. I was trying to do some work, but he cornered me, and the obvious intent here was to get free legal advice. I'll just ask him a question. It's friendly. He's going home on on the boat. It's like no big deal. But anyway, he asked me this question, and it was quite a significant matter, and so I thought, well, I'm not going to give free legal advice and then get sued for not making any money, and so I said, look, Daryl, this is extremely complicated, and I said I can't just tell you right here, what your potential corporate liability would be in this situation. I'd have to investigate. So if you want to, retain me and come into my office, fine. And then he said, oh, okay. And he handed me his business card, and it had the corporation name, and then it had his name, and under his name he said partner. And so I said, Daryl, just a quick question. Are you a corporation or are you a partnership? And he said, oh, no, we're a corporation. And I said, why does it say partner? And he said, well, because we're partners in the corporation. And I thought, here's a fairly sophisticated business person that's making that error. So you have to be very, very careful. And that'll probably be in the problem on the exam. And somebody's going to say, yeah, we have a corporation, here's my partner, and I want you to identify that for sure, because that's a serious, easy mistake to make out in the marketplace. Okay, so the first advantage of corporation is limited liability. The second advantage is your corporation goes on forever and ever and ever. The Hudson's Bay Company started in 1640 as the Governor and Company Adventures of England trading in the Hudson's Bay. 1670, not 1640. A difference of 30 years over, 400? Anyway, 600, something like that. Anyway, Hudson's Bay Company is still in existence, although all the natural shareholders are not alive today. The shares get transferred from generation to generation to generation, but the corporation goes on. Separation of ownership and management. You can actually have a board of directors that manages the corporation and shareholders that elect the board of directors, and they don't necessarily have to be the same or all of them the same. So if you have some marketing problems or something like that, you can actually get a board of directors and entice a couple of people to be on the board who have marketing expertise. Ease of sale of a business or an interest in it. You have 5 shareholders. One of them wants to leave. You don't have to dissolve the business and incorporate another company. That person just sells their shares. No loyalty or duty of good faith by shareholders. Somebody can be a shareholder in your business and they don't even have to vote at general meetings or extraordinary meetings of the shareholders. And they don't lose their shares or anything like that. So this is an advantage because it will allow you to get some people to invest in your business when they don't want to be involved in the business, but they want to be entitled to dividends. Then the last advantage is possible tax advantages. And here again, I am not going to play accountant, okay? I'm very cautious about the cost and profitability stage. And I gave you a disclaimer that I am not an accountant and I struggle with that material myself, so it's not going to be surprising that you struggle with it, and we'll work together, okay? Possible tax advantages of a corporation. Let me explain it this way. You're in a sole proprietorship and you start making more and more money. Pretty soon when you're hitting $120,000 in income a year, the government's taking at least 50% of that. So suddenly, you're in partnership with the government because they're taking 50% of everything. They're just not contributing to the operation. Anyway, there's nothing you can do about that. But if you have a corporation, have some Class A common voting shares and some Class A or Class B non-voting shares. Give the Class B non-voting shares to your spouse or significant other or your children, and you can declare dividends and give them money even though they're not involved in the business. And the money, if I gave it to my spouse, would technically stay in the family, but I wouldn't have to pay tax on it. So you can do things like that. And also, my client up north has been making money hand over fist for years, and so they've got some money in their corporation contingency fund. Well, if the sons decided not to take over the business and they sell it, someone will buy the shares, someone would buy the assets of the corporation, but they would keep the corporation. The contingency fund would remain with the corporation, okay? And they would have money in a corporation that is non-operational, but they could take it out slowly as dividends or return of capitals over their retirement years and reduce their tax liability. So there's things that can be done, but my answer to it is go see an accountant. All right, disadvantages of the corporation. It's more costly to set up, not much more. Let me explain. If you establish a partnership, you can probably do that yourself for about a couple $100. If you incorporate a company, you can do it yourself, but I caution you against it. The book says you can, and the corporate registry says you can, and people do it, and they get into trouble. And I'll come back to explain that. But the cost is more than a partnership. But in a partnership, you need a partnership agreement. In a corporation, you need a shareholders agreement. And so there are significant costs. Regulatory requirements, it says this is a big problem. It's just not, okay? Now, if you're one of the big boys, the big boys that Peter Drucker rubs elbows with, then you're in a public corporation and you have regulatory requirements. Well, you can't even see my hand. It's so high, it's off the screen, right? But if you have a private corporation, so there's 2 or 3 or maybe 5 of you, form this corporation and start making money, I would keep my corporations in good standing by filing the necessary documents they need every year for a little less than $300. Not a big regulatory rigmarole. Inability to flow losses through is a very important one for entrepreneurs. My all-time limit client, Ray, started a corporation, started a business, had a loss. Okay, went out of business. Started another corporation, went out of business, had a loss. Started a third one and started doing really well. Well, it would be nice to be able to take those losses from previous years and deduct it from the income of the successful corporation, but you cannot, because those are three separate legal entities. If I'm a sole proprietorship and I have a loss, and then I'm a sole proprietorship and I have another loss, and then I start a third business and I start making money, well, those losses are mine. So I can then deduct those losses from the income I start making in my successful business. But you cannot do that with a corporation, so that's definitely a disadvantage. The next one is cited by the author as a definition or a disadvantage. Oh, if you have a corporation, the bank will want you to sign a personal guarantee. So even though you have a corporation and all the debts and obligations are the corporation's, suppliers can't sue you, unsuccessful customers can't sue you, they can only sue the company. Your bank can sue you because of the personal guarantee. That is not a disadvantage of a corporation over a partnership or over a sole proprietorship. And let me explain. Oh, I'm personally on the hook with a corporation. Oh my gosh, that is a disadvantage. No, it's not. Why? Because I'm personally on the hook in a partnership and I'm personally on the hook in a sole proprietorship. In the sole proprietorship, I sign the loan document. In a corporation, the corporation signs the loan document because it's a separate legal entity, but they want a personal guarantee from me. So it's like me signing the loan document. So it's just not a disadvantage. Okay, so the corporation is a separate legal entity. How? Well, the BC Corporations Act, Business Corporations Act, says in Section 30 that it is, and in Section 87 it says the shareholders are not responsible for the debts and obligations of the corporation. So that means that if we go back to slide 92, and you see that corporation with the four arrows down to the shareholders elect the directors, and the directors appoint the officers. Section 87 of the BC Business Corporations Act says that shareholders are not liable for the debts and obligations of the business other than what they invest. So I invest some money, the corporation goes insolvent, I'm out of luck, I don't get my money back. But if the corporation goes insolvent owing millions of dollars, nobody can come to me and say you have to pay more. Okay, so that's the advantage of a corporation. In a big, publicly traded company, that's done to encourage people to invest. The directors and officers would also be liable if it was not for agency law. Okay, so corporate law, the BC Business Corporations Act, protects the shareholders. Agency law protects the officers and the directors. So there's this thing called the corporate veil, which is a barrier between the shareholders and the directors and officers and the corporation. So here's the corporation, and there's this big barrier of protection that says, here's the shareholders, directors, and officers. If someone sues the company, they cannot pierce the corporate veil and make them liable. Well, clearly we can see that statute law says that the shareholders are not liable. But the officers and directors, they're not protected by the statute. So they're protected by common law. They become agents for the corporation. And so now we flip to screen 95. The principal in an agency relationship is the corporation itself. And then there's the officers of the company, like the president or director or vice president, brings, I'm pointing at the screen because I see it, but you don't, I'm pointing at you. Oh, it'd be much nicer in a classroom where I could point at this on the whiteboard. Anyway, the corporation brings or the president brings the corporation into contracts with a third party, the customer. And the corporation pays the president for doing that work. If the contract is breached by the corporation, who can the customer sue? Well, privity of contract says the contract is between the customer and the corporation, so the customer can only sue the corporation. Okay, but let's say that the customer doesn't pay and the corporation has sent the goods. Who can the corporation sue? Can the corporation sue the president because the customer didn't pay? No. The corporation can only sue the customer. So the president of the company, or the officer of the company, is actually serving as an agent. And agency law says that the customer can only sue the corporation, or the corporation can only sue the customer. So the agent is protected, right? So agency law protects directors and officers. How does it do that? Well, one of the things is you have to make sure that everyone knows you're dealing with a corporation. And if you have a corporation named Peak Performance Pontoons, Inc., then you would sign a document with the name of the corporation at the top, then a signature line, and per at the beginning of it, and authorized signatory underneath it. And this, slide 96, it's Benton Counter signing per the corporation. What's per mean? Well, per means on behalf of. Let's see if I've done this. Yeah. So slide 96 shows you how you would set up the signature lines. On behalf of would not be there. Okay. And I should probably take it off the screen. I'm going to do that right now so you won't see it. Okay, that's how you'd sign. Slide 96. At law, what it means is Benton Counter is signing on behalf of the corporation, and you can only be an authorized signatory for somebody else. So obviously, if he puts authorized signatory below his name, it's a further indication that he's signing on behalf of somebody else. Oh, somebody else? Well, that's a corporation, because a corporation is deemed to be a person. Okay, so when you sign contracts or letters or emails, you should always sign them that way, because then you have no personal liability. Okay, that brings us to partnerships and our partnership contracts and shareholder contracts. And the textbook really doesn't deal with them. A partnership agreement if you have a partnership arrangement, and it's a risk management measure, and you should budget for it in your cash flow. And if you have a corporation, then you should have a shareholders agreement. And let me tell you why. I had a client who ran a small advertising agency, and I got to know him really well because I did the legal clearance for him. He got tired of that and he sold it, and he wanted to go into partnership with a friend of his, with a friend of his to run a cruise ship franchise. And they were allowed to establish a partnership, which their accountants suggest they do for write-off purposes. It was a relatively low-risk venture because there was lots of demand, and so they set up the business as a partnership. And they came to me and they said, what do we need? And I said, you need a partnership agreement, because they wanted to not necessarily pay out the money 50-50, okay? By that they meant that if 9 to 5, if they did any work, then that was considered partnership work, and the profits was divided 50-50. But if someone said, well, okay, I want to come in the evening after closing and use the facilities, the computers and everything, and the contacts and everything, to do extra work outside of the normal business, then I get to keep that myself, and the other partner who didn't work on it doesn't get any. And so I said, okay, well then you definitely need a partnership agreement. I prepared it and sent it to them, but they were busy with FAM tours, which is familiarity tours of ships, and they were busy setting up their office, dealing with the landlord, doing their leasehold improvements, getting in their electrical and power, and learning the franchise system, and just a multitude of things. So they kept saying, oh, well, we'll get to it later, we'll get to it later, we'll get to it later, and they never did sign it. And then eventually what happened was my client of the two, it was my client of the two. I didn't handle the partnership. I handled it for my client. Came to me and he said, there was a Noordam cruise ship that dinged a propeller coming down from Alaska, and they were going to put into Vancouver, and it was going to take them 2 days to fix the computer. So they had to cancel a whole 7-day cruise. So they'd sailed from Vancouver up to Alaska and back in 7 days. But the ship had to cancel 7-day trip because they could only do 5 days. So they gave everybody money back, and the ship was going to sit idle in Vancouver for 5 days, or 7 days. No, 5 days. 2 days to get the propeller fixed and 5 days idle. My client went to them and said, I will charter your ship for those 5 days. It means I'll pay you, and I want the ship to go up to Alaska and back without stopping at any ports. Just up there, one port, back. Okay? For Holland America Lines, this was found money, okay, because suddenly they were going to be paid something, whereas before they were going to get nothing. So they entered into this agreement because my client had also been dealing with I think it was one of the associations in town. One of them, like the BC Automobile Association or one like that. And they wanted to do something special for their annual general meeting, the 50th year annual general meeting or something. So he went to them and he said, okay, how about this? He said, your members can go on a 5-day cruise for their annual general meeting. And they went, wow, that's fantastic. And so there were 1,200 rooms. It was a small ship back in the old days when the ships looked like ships rather than floating hotels. And so he sold 900 of the 1,200 rooms, just like that. And he did it after hours, okay, all the work. And he came into the office one day and he says, I'm in the money, I'm in the money. And his partner says, what? And he explained what's going on. And she said, how much are we making? And he goes, no, you don't understand. I did it after hours, so it's how much am I making? And she said, no, I don't think you understand. We never did sign that partnership agreement. And so the Partnership Act applies, and any money that you make that is related to the business at all or the use of the business assets is partnership money, and it gets divided 50-50. And he called me up and he said, Peter, I know the answer to this, but tell me anyway, am I out of luck? And I said, Cam, you never signed that partnership agreement. And so the Partnership Act applies, and the Partnership Act says that is partnership income, and the Partnership Act says it's divided 50-50. Okay, so he made a lot of money anyway. And he was the kind of guy that rolled with the punches. So he said, oh, well, okay, she has to sell the other 299 rooms. Wait, I said there were 1,200, and I said he sold 900. Why is she only selling 299 and not 300? Well, because the other room was a suite, which was given by Cam to his lawyer for doing the legal work. So rather than pay me cash, he paid me in kind. I reported it as income, believe me, but he paid me as in kind. The only time I've ever gone on a suite on a cruise. Anyway, you'd think he would have learned his lesson. A few years later, the accountant comes to them and says, hey, you're making so much money that it's time to incorporate so that you have tax savings. And so they come to me and they say, all right, we're going to incorporate. What do we need? And I said, you need a shareholders agreement, which will look substantially like the partnership agreement. But it doesn't deal with the Partnership Act. It just deals with everybody's responsibilities under the Corporations Act. And they said, okay, prepare one. You know where I'm going with this, don't you? So I prepared, send it down to them. Oh, they're really busy. They'll get to it later. They're really busy. They'll get to it later. And they never sign it. Okay? Well, a few years go by, and Cam is tired. And so he says, to his partner, to his business associate. Okay, she originally was his partner, but then they incorporated. They're no longer partners, business associates. So he says to his business associate, I found somebody who wants to buy my shares. I'm going to sell them and withdraw from the business. I will continue to work and sell cruises, but on an agency relationship where you just pay me some money. And she said, oh, I don't think so. And he said, what do you mean? And I said, well, this person can come on board. They can invest money in the corporation, and we can use it, and they can become a business associate, but you cannot sell your shares. He said, well, yes, I can. Anybody in any corporation can sell their shares. And she goes, no, I don't think so. Well, under a private corporation, because they're not listed on the stock exchange, the sale of shares have to be approved by the directors. He was a director. She was a director. He said, I approve the sale. She says, I don't. So she gets the investment from this new person into the business, which allows it to expand, and Cam's stuck in the business. Now, he doesn't have to be a director. He doesn't have to be an officer. He actually doesn't have to work in the business. And if this woman declares dividends, he will get them. But he won't get dividends on a 50-50 basis because now there's 3 shareholders. He'll only get 1/3 of the dividends, and he cannot sell his shares. So he cannot get the value of his business out of it. Why? Because he didn't sell or sign a shareholders agreement. Okay? So you get the partnership agreement signed before the partnership begins, and you get the shareholders agreement signed before the company begins. Otherwise, it just seems like everything's going along swimmingly, and we just don't have to do that. It's like legal stuff that really isn't important till it comes back to haunt you. The partnership agreement and the shareholders agreement are part of the succession planning. If you're leaving the business to a family member or to key managers or selling the venture, you want to be able to do that, number one, and number two, you want your family members to be bound by the agreement. Okay, so you should take that into consideration. And that brings us to estate planning or succession planning. There are 5 documents that you should get together and have to have your estate or your succession plan in place. And they are listed on slide 69. No, is that 99? Wow, we're at 99 already? Whew. Okay, slide 99. You want to have a last will and testament, which is the document which is only becomes valid and speaks from the date of death and says who gets your assets. Okay. However, we have this tremendous capacity in a lot of cases to keep you alive after you're pretty much dead. Okay, you're basically brain dead, but they keep you alive until somebody has the power to pull the plug. What happens to your business during that time period? You want the business to continue to operate so that you can sell it as an ongoing concern, or if you eventually die, your executor will be able to sell it as an ongoing concern because it'll be worth a lot more money as an ongoing concern rather than just the assets. So you want to have a power of attorney which appoints someone to take care of the business. Now you may or may not want that person to do your personal stuff, your personal banking, your pay your bills, your hydro and stuff like that. So it may be, and it's probably wise to have a power of attorney given to somebody who is restricted to doing that, and then a power of attorney given to somebody in your business restricted to taking care of your business. Well, I'm getting the sun on me here, and it's making it really hard for you to see. So I think what I should do is probably change there. Is that a little bit better? All right. So that's the last will and testament, and power of attorney for business, a power of attorney for personal matters. The other thing is when nowadays when something happens and you are, taken onto a ventilator or something, which is very, very serious and very common now with COVID, at some point you may be brain dead, and then the question comes, who makes the decision to take you off the ventilator? Now, if that was my spouse, you would think I would have the right or the ability, but I don't. Okay, they're a separate person from me. So the only way that I could pull the plug to bring my spouse's life to an end, which might be merciful or at least financially advisable for the family, it's extremely difficult, but nobody has a right to do it, not even the doctor. Except in extreme emergency situations, which might be starting to happen in COVID cases where they have a lot of people on ventilators and they have to decide who lives and dies. But aside from that, nobody has the right to do it. I can't say, oh yeah, that's my wife, and I know that she wanted to not live like that, so pull the plug. The doctor will go, no, I can't do that because that would be malpractice, okay? So nowadays you can have a representation agreement only since about 2006, okay, where you appoint someone as your representative to make medical decisions for you when you cannot do it yourself, all right? You want to be very careful with that document, okay? Make sure that the person that you appoint as your representative really knows your wishes, and you feel confident that they will abide by them. And then the last document is not a legal document. It's merely a letter, I call it a comfort letter, that you leave with your family member or in your safety deposit box, just saying things like, I deal with these insurance companies, I deal with this investment company, I've got these GICs, I've got these insurance policies, I've got, and my will is located at such and such, and you give that comfort letter to somebody. Because besides the trauma of your death, which should upset somebody, hopefully, there's always the horror of having to go through their personal effects and their papers and everything to settle their estate. And if you don't know where they bank, and if you don't know whether they have a will, or where they've got insurance or things like that, it can be doubly traumatic. Okay, so from the point of view of the person who is putting their estate in order, you should actually get a comfort letter and give it to somebody. It can also do things like, I had a client pass away, and he had a signed picture of Bob Hope. You're all sitting there saying, who? Bob Hope was one of the all-time great comedians in Hollywood, okay? And he got a signed picture, and he really liked it. And he also had a watch that was given to him when he quit working for the Vancouver Sun. And it was a gold watch. And one of his sons liked the gold watch, and the other son really liked the picture of Bob Hope. And so in his estate, he said, I'm leaving my picture of Bob Hope to Stevie, and I'm giving my watch to Donnie. Okay. And and the watch is worth a heck of a lot more monetarily than the Bob Hope picture. So he said, just to let you know, I've left some cash to Stevie, who's getting the Bob Hope picture. Or was it vice versa? Doesn't matter. Because that will make it equal to the watch. Okay, all right. So, and you just explain things like that. You don't put it in the will, because the will can be challenged in court. Okay, but you just tell your kids, look, this is why I did it. All right. So that's estate planning. Now, just some advice about choosing your name, which they talk about in the textbook. first example, Jacqueline Java wants to start a coffee shop called Gotta Have a Java. And Jacqueline should have a capital J. So let me just put that capital J in there. And why didn't it go capital? That's better. Okay. It's one of those situations where you've got to make sure that the name fits the requirements of the government. Okay, so the first step you do is you do a trademark search federally to make sure no one else in the whole country is using Gotta Have a Java, because they have better rights to the words than you do. So you do a trademark search, nothing there. So my advice is you also do it in the United States, okay? Because under NAFTA, there are rights. Somebody in the United States can stop someone in Canada. Wouldn't be a problem so much with Mexico because it would be in Spanish and no one would be confused. So you do a trademark search in Canada and the United States, and you can do those yourself. You go online, and it's a word mark, so you just put in the words, and up comes and it says, no, there are no marks out there, or yes, there's a Java coffee company, and you go, is this serious? How big are they? Are they distributors, or are they got a coffee shop? Because if they have a coffee shop, they're in the same business as you, and they could say it's going to be confusingly similar, and they could stop you. You already paid the money. You registered the name provincially. You've got a corporation name, and they come back and say you have to change it. No biggie, you can change it, but it's going to cost you. Okay, so you do the trademark search, then you register the name with the provincial government. Which you do, strangely, for a sole proprietorship under a partnership form. Don't ask me. Just the way it is. Then you apply to the municipal government for a business license, and the business license would say Jacqueline Java, doing business as Gotta Have a Java. Okay? Then you register the name Gotta Have a Java with the Canadian Intellectual Property Office. In other words, you apply for a trademark. Once you've applied to register the name, get to work. Okay, that's the process. Next screen. Jacqueline Java and her friend Carl Coffey want to start a shop together called Gotta Have a Java, but it's a partnership. So Jacqueline Java and Carl Coffey, a partnership is the name of the business. That's what you would register with the government or with the municipality when you get your business license. You do the same trademark search, okay? Then you register the name with the province as a partnership name, and then you apply to the municipality for a license, and then you register your name, Gotta Have a Java, with the Canadian Intellectual Property Office as a trademark, and get to work. No, you think for liability purposes you want to have a corporation, so Jacqueline Java and her friend Carl Coffey decide that they're going to have Gotta Have a Java Corporation. Well, it shows you the name on the screen, 102, and it's to comply with the BC Business Corporations Act. There has to be a distinctive element, a descriptive element, and a legal element. They're a little loose on this. You could have Java Enterprises. Okay, Enterprises doesn't describe what you do, but they accept that. Okay. But anyway, Gotta Have a Java would qualify as the descriptive element because it means you got to have coffee. And it would also comply as the distinctive element because you've checked the register and nobody else has a similar name. Then you need a legal element at the end of that. So it has to end in Ltd, Inc., or Corp. That means you are a registered corporation under the BC Business Corporations Act. You can have Gotta Have a Java Limited or Gotta Have a Java Incorporated, but you have to be consistent in the use of it. First step, trademark search. Second step, register the name with the provincial government. Actually, I got to take that out because you don't register the name of the. You apply for a name reservation, which means you go to the BC Business Corporate Registry, and you say, "Here's my name that I want for my corporation, and they check the register to make sure there's nothing confusing as far as they're concerned, and then they grant you the right to incorporate your company under that name. You apply for your business license, but you don't apply for it as Jacqueline Java or Carl Coffee. You would apply for it as Gotta Have a Java Ltd. Okay, then you register your name, Gotta Have a Java, with the trademark office in the federal government, and you go to another slide, which I'll explain in a second, and then you get to work. Okay, so that's how you do the name business. Now, the slide that you have to go to, just give me a second here because I didn't insert it. Okay, I've made a slight change, and thanks for bearing with me. It's slide 102, and now you've got a trademark application in for Gotta Have a Java. You would probably do it as Gotta Have a Java rather than Gotta Have a Java Ltd, because in your marketing you're probably going to want to use Gotta Have a Java without the Ltd because it's easier. So what you do is you register Gotta Have a Java as a trade name with the government. It costs a little bit more money, but not too much. But on whatever you do, you would have to have Gotta Have a Java, and then somewhere there would have to be the full corporate name. So you apply for the trademark, but wait a minute, you're not operating yet. So how does that affect your mark? Well, you become the owner of the trademark to the exclusion of others from your date of first use, or from the date you applied on, if you apply on the basis of intended use. So in your trademark application, you say, we're going to use this. We're not yet, but we will. And so you apply for the trademark, and it usually takes 2 or 3 years to get your registration. It shouldn't, but it does. And so you'll probably wind up operating before then, but you apply on the basis of intended use. Everybody out there goes, well, okay, wait a minute, we can't use that name because they have a prior better right to it than we do on the basis of intended use. If you don't use it, you lose it, but eventually you start using it. Or what you can do is you can start using it immediately in some way. You can do promotional materials, opening soon, Gotta Have a Java, and then you specify a date in your application that you began using it on such and such a date. Okay. Anyway, that's the kick up to slide 102, but there's other information on slide 102 that we'll deal with in a sec. Okay. Now we're going to go right into, because that leads nicely into protecting your intellectual property. And intellectual property can be described as intangible property that is the product of mental activity. Okay, and a intellectual property, if it's just an idea, is not protectable. But we'll get into that later on. One term that you have to know, only because of the Americans. And because sometimes there is a border and sometimes there isn't, is they refer to intellectual property as know-how. Well, how are you going to protect your know-how there, guy? They tend to butcher the English language or reduce it to some common denominator. And so they call intellectual property or proprietary information your know-how. And so you make it a legal document, which talks about the protection of know-how. And so rather than say, oh, it's a typo, now you know that it's just their way of referring to it. Okay, you can protect your idea or your concept in basically 5 ways. There is an Integrated Circuit Topography Act if you're going to make computer chips. And there's a Plant Breeders Act if you plan to create a new plant life form. On the assumption that we're not going to do either of those, there are 5 basic ways that you can protect your intellectual property. One is through trademark, copyright, patent, industrial design, and confidential information. Okay, so a trademark is a name, a logo, or a symbol, and it's protected. I made a typo there. I'm just going to fix that before I forget. Or a figure. And it's protected two ways, and everybody loses marks on the exam because I put it on and they only put down one of the ways. Heads up, trademarks are protected two ways. One is the tort of passing off. So somebody opens up a coffee shop, get your Java cat, get your cat, you have to get your Java, and you go, wait, no, that's confusingly similar. Well, you haven't registered your trademark yet, but you can sue them for passing off because they're passing off their business as yours. Even if they don't intend to, if there's confusion in the marketplace, you can sue them for the tort of passing off. Okay, but if you registered your trademark, then you can sue them for infringement of your trademark and passing off. Okay, and then you have more remedies. How do you register? Pursuant to the Trademark Act. So it's a federal statute. It means you're protected all across Canada. Even if somebody in Newfoundland uses the name and doesn't know about you, you can stop them. Okay, if you don't register your trademark and you're using it in BC, they may be able to use it in Newfoundland and you won't be able to stop them because nobody there is confused because nobody knows you exist. Okay, so you want to register. But if you're in North Vancouver and the person has a confusingly similar name in North Vancouver, you can stop them, suing them for the tort of passing off. We talked about the intended use, actual use difference. That brings us to copyright. It used to be that this was for artistic works only, but there's so much artistic inputs into a business now that they that instead of talking about industrial property and intellectual property, they've just now talked about intellectual property. Copyright is an original literary, dramatic, musical, or artistic work, okay? And you protect it under the Copyright Act. Now, I have written some children's books. I'm automatically protected. I don't have to file. The second that I've done that work, that's my work, okay, unless I've copied somebody. Then why do we bother filing? Well, we file because it gives you an advantage in court. If you have copyright but you're not registered, then you have to, when you're suing somebody, prove that you've got copyright and then prove that they have infringed it. If you register, then that means you only have to say they infringed it. They have to prove that you don't have copyright, and that's going to be pretty hard because you've registered. So your rights are better under the Trademark Act and the Copyright Act if you register. Patents have to have three elements: novelty, utility, and ingenuity. Novelty is it has to be new, so you can't get a patent on something that somebody else already has a patent on. It has to have utility. It has to be useful. There was a fellow that invented the pet rock. Okay, a rock is a perfect pet because you don't have to feed it, you don't have to clean a dirt box, you don't have to take it for walks, and it was silly. Okay, but people bought it. Okay, and he'd put eyes on them and ears on them and fur on them and sell these pet rocks, and everybody was buying them. It was a real craze of quite a few years ago, and other people, in order to try to stop other people from doing it, he filed for a patent, and they said, well, it was ingenious, but it has no utility because it doesn't do anything, and it's not novel because it's just a rock. Okay, and so he could not get a patent, and so other people, began doing knockoffs. So it has to be new, it has to have a useful purpose, and there has to be an ingenious element in the creation of it. You're protected pursuant to the Patent Act. You're protected for a 20-year period, right? If the idea is to keep the competitors out of the marketplace, you can actually wind up being protected much longer than that. But here's where you have to have a lawyer. The applying for a patent is really quite confusing, and it will get kicked back and stopped, and you have to make amendment after amendment. And so you should really get a patent attorney to do it. And your patent attorney, if they're good, will say, okay, yes, there's a really good likelihood you're going to get this patent. And what I can do is I can do my work really fast and really well. In about a year and a half, you'll get your patent. Or I can drag my feet and you can get your patent 3 years from now. Why? Well, you're protected for the period of the patent, which is 20 years. But if I file a patent, nobody in their right mind is going to copy it, because they'll start making money. And when I get my patent, I'm going to be able to go to them and say, thank you, give me that money because I have a patent on it. Okay? So they're going to wait to see if you get your patent. Well, if you really work hard, you can get a year and a half, or you can drag your feet and drag out the process for 3 years. During that period, you mark your product patent pending. Everybody goes, whoa, better not copy that because they're going to get their patent and they're going to come after us. So instead of having a patent for 20 years, you can have a patent for 23 years. How can you drag it out? It's really quite simple, and this works for trademarks as well, but there's no point in doing it for trademarks because your protection continues as long as you use your trademark, whereas a patent it exhausts after 20 years. So you file, and it takes them about 3 months to say, thank you, got your application form. And then it'll be another 3 to 5 months, and they'll come back and they'll say, we want a correction. You have 6 months to file that correction, and if you don't, your patent application expires. Well, wait 5.5 months and then file, because your application is still valid, but you've dragged out that process for quite a while. They will then say thank you, and then they will ask you to make some other change, okay? And you rush and get it in quickly because you want your patent. No, you don't. You drag it out, okay? And so you can drag it out for quite a while and give yourself some additional protection. An industrial design is a shape, configuration, or ornament which appeals to and is judged solely by the eye. So if I said the Heinz ketchup bottle, which looks like this, even before I held it up, most of you could say, yes, I can see that shape. What Heinz did was way back in about 1976, they redesigned their bottles for ketchup, mustard, relish into that shape. And they filed an industrial design. And an industrial design is good for 10 years. It used to be that it was good for 5 years, and then you could get a 5-year renewal. But now we've gone with something the same as the World Intellectual Property Organization, and it's good for 10 years. After the expiration of 10 years, can somebody use the shape of that bottle? Well, they would not be infringing the industrial design because it's expired. But Heinz Ketchup sued people saying, we've taken that industrial design and made it into a three-dimensional trademark, which we cannot file and protect pursuant to the Trademark Act because they only take two-dimensional images. But they could sue for passing off, because if someone else uses that shape, then they're passing off their ketchup as our ketchup. And so they were really quite clever about it. All right, confidential information is an idea protectable only by contract or by a fiduciary duty. And this is particularly important to what you're going to be doing because you're going to produce a business plan. And the business plan is about your idea, and if other people see it, they can steal your ideas. So we'll get back to that in a minute. So it's only protected by contract or fiduciary duty. Why? Because as I explained in the previous stage, someone can steal my computer. Hey, wait, where did you go? Because it is a tangible personal property object. But an idea is not subject to theft because it's intangible. Okay, theft is controlled by the Criminal Code of Canada. That was set out in the Regina versus Stewart Supreme Court of Canada decision many years ago. However, if I have proprietary information, I can protect it in NDAs, employment contracts, and through a fiduciary relationship. NDA, a non-disclosure agreement. used to be called a confidentiality agreement. Now they call it an NDA. What it means is I have proprietary information, which is an idea only. And so what I'm going to do is I'm going to divulge it to you, and I don't want you to take it and use it yourself. And so you get someone under a contract to sign an NDA, and then they are bound by contract not to do it. I had a client, an ad agency client. I dealt with the president of this business for many years, clearing the ads. And he called me up one day and he said, Peter, I've got this idea and I want to get a copyright, trademark, patent thingy on it. And when he said thingy, I knew he really didn't understand what he should be doing. And he said, it's really urgent and I have to see you. And I said, come right over and I'll see you. And he came over to my office and he sat down in front of me and he said, okay, I've got this idea and I want to protect it. I don't want to do it. I want to sell it. But if I tell somebody, they can do it. And I said, okay, what's your idea? And he went, I went, what? And he said, if I tell you, you could steal my idea. And I said, okay, have you got a loonie? And he said, what? And I said, have you got a loonie? And he went, well, yeah. And I said, give me a loonie. And he went, oh, okay. And he gave me a loonie. And I said, all right, I've been retained as your lawyer. I now cannot capitalize on that. And, oh, okay, I'll tell you. I didn't need the loonie. As a lawyer, I was already under this duty to not divulge it. But I figured, why not get a loonie? Just kidding. Anyway, he said, okay, my idea is, and without a word of lie, here's the person in a three-piece Gucci suit and a real mover and shaker in the marketplace, and he gets up and he looks up and down the hall, closes my door, and looks at me and he says, are you ready? And I said, yeah. And he said, no. He said, are you ready? And so I thought, oh, I better play along here because he really thinks this is a big deal. And I said, yeah, okay, sure, I'm ready. And he said, all right, advertising on the ceiling. And I went, he's kidding, right? And I thought, no, my God, he isn't. And so I went, good idea. Well, it's not a bad idea. But anyway, I tried to explain to him, okay, there's no design element here, so there's no industrial design. There's no trademark because you don't have a name for it. There's no copyright because there's no artistic element to it. So that would leave patents. Patents, utility, novelty, and ingenuity. It's incredibly ingenious, sort of stroking your client, right? And it has utility. Oh, but wait, it's not novel. We have advertising in TV, radio, magazines, newspapers, walls, billboards, bus signs. This is just advertising on another surface, a ceiling, right? But just another surface. So we can't get a patent. So I said, okay, that leaves NDAs, non-disclosure agreements. And he wanted to go to Seaboard Advertising and sell them his idea. So he went there and Seaboard Advertising signed an NDA, and don't do an NDA agreement yourself. Okay. Because the company, Seaboard Advertising, is a corporation. It has to sign. And the person you're actually talking to has to sign. And there has to be consideration. You have to pay them $1 to get the contract to be binding. Or you have to sign it under seal. Okay, if you don't know how to do those things, that's why you get a lawyer. Anyway, he went to Seaboard Advertising and they signed the confidentiality agreement, which I drafted. And he told them, and they said, oh, wow, that's kind of an interesting idea. Yeah, we'll pay you something for that. And he said, great, how much? And they said, $10,000. And he said, oh, hey, no, I want like $1 million for this. Obviously, Seaboard Advertising wasn't going to pay him $1 million. He wasn't satisfied for $10,000, so Seaboard Advertising couldn't do it. Okay, until somebody else did it. Okay, and then as soon as somebody else did it, it's in the public domain. Okay, it's not an idea that can be protected anymore. It's in the public domain, and then they were allowed to do it for free. But non-disclosure agreement should have been what my BCD Electronics client did when he got that fellow to do the software for the handheld rivet checker. Okay, he should have got him to do a confidentiality agreement so he could not go out and do it on his own. And that agreement should have said, "You're doing this for me, and I own it." All right. If you want to get a prototype built for your idea, whatever it might be, and you're going to go to somebody and they're going to build it for you, get them to sign an NDA, or they go, "Hey, I'm building it for you, but it's my idea. I can do it myself." You're also going to have employment contracts with your employees, and the last thing you want to do is divulge your proprietary information to them, train them to do the work, and then have them go, "What a great idea," move across the street and use your information or your client lists and compete against you. So you want to have an employment agreement with your employees in writing, okay, with a non-disclosure clause in there that your proprietary information is protected, and then you want to have a non-compete clause in there. Then the last one is looking at it from the other side of the coin. Let's say you're working for somebody and you're a manager. Okay, if you're a lowly, grunt worker, you're okay. But if you're a manager and you started working and you did not sign an employment contract with a non-disclosure clause or a non-compete clause in there, and you're sitting there thinking, "You know what? I could go and do this a heck of a lot better. I find where I'm working is really restrictive." So you say, "Okay, that's it. I quit," and you go and you compete against them, and you get sued. You say, "Hey, I didn't sign an NDA or a non-compete clause," and the courts are going to say, "Hey, you're a manager. You are under a fiduciary duty to not disclose or not use that information yourself." Okay. All right, so the last part of this chapter is, again, something that you don't find in the textbook per se, but they talk about it on page 219. Okay, let's take a quick look here. Let's see, 219. And it's point number 7 under no money, startup miracle, other considerations. It says, "Pay your lawyer as little as you safely can. How can you get legal help you'll need without blowing all the money you've saved elsewhere? Start by using downloadable templates for legal documents such as founders agreements, intellectual property agreements, because there are major differences between Canadian and U.S. laws. You have to be careful." And that says, "Be cautious. You'll need to pay a lawyer some money." So the idea is that you don't want to be on the cheap with your lawyer, but there are things you can do to use your lawyer's time more effectively. And they touch on it in the textbook. There's an article which I got off, I think, Profit Magazine, way back when. It still remains valid. And it says, use your lawyer's time effectively. You can use precedents, but you just don't go and get a precedent and say one size fits all. There was one of the best stockbrokers in all of British Columbia. She was making well over $1 million every year. And that was years ago. And she would hire people to do grunt work, and she would get them to sign a non-compete clause, and it said that you won't compete with me in the stock market business in the province of British Columbia for 5 years. That's unenforceable in court. And one of the students became a grunt worker for her. He was going after his certificate to become a stockbroker. And she made him sign this agreement because during that year that you take your training, you have to work for somebody. And so he was really happy that he was going to get to work with this stockbroker because she was the best in the province, probably. And And he came to me and he said, I don't know what to do. He said, I cannot miss this opportunity. It would be wonderful to be trained by her. But if I sign this agreement, I get my certificate and I can't work in BC for 5 years. And I said, what's your problem? And he said, what do you mean? And I said, sign it. And he goes, what? No, you're not listening to me. And I said, yes, I am. I said, nobody can get you to sign an agreement that's going to stop you from working in the province of British Columbia as a stockbroker, because you can't take your certificate into Alberta and use it because it doesn't qualify there. So you would be prevented from working after being trained. 5 years is too long. And I said, where did your clients come from? And he said, oh, she's in Vancouver. They're all from pretty much Vancouver. Then I said, go back and tell her that you'll sign an agreement because you want to go back to your hometown in Kelowna and be a stockbroker there. So you're not going to compete against her, but she can't stop you from competing in the province. And he went back to her and he said, my lawyer told me to sign it. And she said, oh, good. And he said, no, my lawyer told me to sign it because it would be ineffective and unenforceable. And he explained why. And she said, oh my gosh. Oh, and she agreed to have him sign one where if he wanted to work in Kelowna, he could, okay, because they wouldn't be competing. And then afterwards he said, and just out of curiosity, what lawyer drafted this for you? And she said, oh, I didn't use a lawyer. She said, I just went to the library and got an agreement, used it. Well, the problem with that is she saved herself maybe $500. And she has all these agreements that are unenforceable. So you can use a template, but you have to take the template to a lawyer and say, look, does this work? Okay. So you can't just say, oh, I can save $500 because it won't work. And you can do other things. Like I had a student go through my the program, and he came back afterwards and he said, Peter, I need an agency agreement drafted. How much will that cost? And I said, about $1,500. And he went, oh, man, I'm just starting out. I don't have that kind of money. And I said, Vince, what did I tell you? And he said, what do you mean? And I said, I told you that you could do the grunt work in preparing a template agreement if you want to, or drafting the agreement in your own words and give it to me, and I will then do the legal stuff to make sure it's enforceable. But all the grunt work will be done, like who the parties are, what their addresses is, what's their contact information, are they corporations, are they partnerships, all that's already done. So I'm not going to bill you for doing it because you've done it. I said, but I will make sure that it's an enforceable agreement. And so he did that, and I wound up charging him $950 instead of $1,500. Okay, so you can do things to use your lawyer's time effectively. Pay them as little as you can safely, but where is that line? I mean, you have to be very careful. Okay, so this article said use your lawyer's time effectively. And the first thing was find a lawyer you like. Hey, let's find a lawyer that I enjoy sitting back and having a brewski with at the end of the day and watching a football game. That's not what we mean, okay? What it means is find a lawyer that you feel comfortable working with. When I moved my law practice home, I talked to my clients about it, and they said, we don't care where you are on the face of the planet Earth. As a matter of fact, you could be on Mars if you wanted, as long as when we need you, we can contact you. Because a lot of lawyers, you try to get in touch with them, they're very busy people, they'll return your call in a day or two. And that doesn't work for some people, okay? So you find a lawyer that you feel comfortable with, that you feel fits your style. And this is something that you should do for lawyers. Find an accountant that you're comfortable with. Find a banker that you're comfortable with. Because I found when I moved my law practice home, we went out and we tried to deal with the bank in Nova Scotia. And they're too big for a small lawyer like myself. I had a personal banking officer. And whenever I tried to call him, it was, hi, this is Darnell Dewey, your personal banking officer. I'm not in right now, but your call is extremely important for me. And I'll get back to you as soon as I can. One time I wanted to get in touch with him. Thank goodness it wasn't urgent because I got that message like 3 times. So finally one day I dropped into the branch and I said, look, can I speak to Darnell Dewey? And they said, oh no, he's no longer with us. He was transferred like months ago. I said, well, he was my personal banking officer. Oh no, you got a new one. Never heard from him, right? So this is Will Smith, your personal banking officer. And they gave me his number and I went home and I dialed it. Hi, this is Will Smith, your personal banking officer. Your call is really important to me. And I went, oh God, I can't stand this. So we went to Montreal Trust. It was very small. There was a manager, a loans officer, and a couple of tellers. I did all the banking. I would go in and I would go, hi, Jan, to the bank, to the manager. I took her out to lunch when I set up my business because I needed a loan, right? No, I took her out to lunch because I wanted to get to know her and her me. Taking somebody out to lunch because you want a loan, it's going to smooth it over, isn't it? No, come on. Anyway, so my business manager and I took her out to lunch and the loans officer out to lunch, and we got to know each other. And then I would go to the branch and I'd go, hey, Jan, how you doing? You got time for coffee? I know she doesn't. Okay. But she would say, oh, no, Peter, maybe next time. And I'd go, okay, sure. And then I'd go to the loans officer and I'd say, I can't remember her name now. It was so long ago. But, oh, hi, sir. How are you doing? And she'd, oh, fine. And I'd say, how's your golf game? Because I knew she played golf. And, 15, 20 minutes later, she's finished telling me the problem she had on the ninth hole, right? And, on the 12th, she was in the rough. And then she'd say, how are you doing? And I go, oh, a divot here, a slice there. I don't play golf. But I wasn't going to tell her that. Anyway, so we got to know them. And it turns out that this was incredibly important to me because I had a client whose money got held up on a transfer from Europe. And so I phoned my client in Europe and I told them that the money was tied up in Toronto. How did I know? Well, I called Jan and I said, Jan, I've got this file and we're going to be closing very soon and I haven't got my client's money. He says it's been sent. And I got her message machine. And so I left a message and I said it was urgent. She was back in touch with me in 20 minutes. I told her what I needed. She was back in touch with me within an hour and she said the money is held up. It's held in Toronto. And so I was able to call my client and I said, you made a money transfer. It's being held by the Royal Bank of Canada in Toronto for 9 days. Why? Because they get to use your money for 9 days. There's no reason that a wire transfer from a Swiss bank, the money isn't any good. Anyway, and I said, we're gonna miss the deadline. My client called the Royal Bank. Okay, my client did not call the branch and ask to speak to his personal banking officer. My client in Switzerland called the president of the Royal Bank of Canada because my client in Switzerland was on the board of directors for the bank. Okay, and he calls the Royal Bank officer and he goes, so, our money is not good enough for you? That's all he said. And that money was released immediately. Well, if I was dealing with Darnell Dewey, my personal banking officer at the Bank of Nova Scotia, I never would have got any results, okay? So it was because I built up this relationship. Not when I needed Montreal Trust, but I built up the relationship when I didn't need it, so when I did need it, my message went right through. Okay? Get your lawyer on time. You got a 2 o'clock appointment. Make sure you're there at 10 to 2. That's not what I mean. My all-time favorite client, Ray, came in one time and he said, here's my contract. Tell me how I did. He'd already signed it. He'd made some real errors in there. And so it's too late, right? He should have come in and paid me to review the contract before he signed it. You get an offer to lease from the landlord. Oh, it's just an offer. It's not a contract. Yes, it is. You sign it, they sign it, you're bound, even though there might be some things you don't like in it. Get to your lawyer before you sign the contract. Franchises. The last stage in this textbook, we may not even get to it because there's so much material, is acquiring a franchise. I had a client that I spent a lot of time with because he was acquiring a franchise. The interesting thing about this franchise was they did not require you to be personally liable. Okay, it was such a substantial franchise that they checked out their people so well that they figured we could do this without personal guarantees, and that made it easier for them to get franchisees. So my client is negotiating with them, and I'm meeting with him, and then one day he calls me up on the phone and he says, Peter, I've got the franchise agreement, and they want me to sign it right now so we can get going. Should I sign it? Well, hey, how do I know? Let me just look through the phone here. Yeah, okay. It's hard to see, but I think everything's okay. Obviously, I said, no, I can't tell you to sign it because you're not in my office. I don't get to see it. And he said, well, I think everything's okay. And I said, okay, the one really important thing is, and I went over this with him, is that you sign the contract not personally, but in the corporate name. Okay, so we're back at slide 97. This is how I told him to set it up. Okay, the name of the corporation per authorized signatory, and then he signs. And I said, are you signing right under the corporate name? He goes, oh yes, I am. And I said, look, I cannot advise you to sign that agreement. Okay. All I can say is sign under the corporate name and maybe you'll be okay. Well, his idea of signing right under the corporate name meant the corporation's name was on page 1, and on page 38 there's a signature line where he signs, and it's right under the corporate name because there's no other documents or anything in between. And I'm going, what? After explaining to him how to set it up, it was really upsetting because he signed just his name there, and something went south, and the franchisor wants to sue, and so they sued him personally, and the next thing you know, he's going to sue me. Okay, my client is going to sue me because he didn't sign correctly. Fortunately, I had provided him a detailed bill in which I told him that my advice was not to sign it, to bring it in to me, and that he should sign in the manner in which I instructed him in the office, where you sign, the name of the corporation per an authorized signatory, and he didn't do any of that, and he is personally liable. And he tried to sue me, and fortunately I had this bill which showed that I'd given him the right legal advice. But you can't you can't go to your lawyer after you've done the deed and say, how did I do? Take a shopping bag. Take a shopping bag, take a briefcase, take a Gucci suitcase, I don't care. But just make sure when you go to your lawyer, you take all your information with you. For you that took BADM 107 for me, I'm sorry this is boring because you're hearing it again, but it's incredibly important, so listen. My all-time favorite client, Ray, called me up one time and he said he's got this contract negotiation going on, and he needed some advice on it, and he started telling me over the phone, and I said, sorry, Ray, you can't do this over the phone. You got to come into my office. So he drives to my office. Now I told him, by the way, I said, and bring $250 as a retainer. And he says, sure, no problem. And he comes into my office, and he gives me the money, and because he's a very slippery client, doesn't pay a lot of people, I counted it. And then I said, okay, let's see the contract. He says, oh, I'm sorry, I didn't bring it with me, but I'll tell you what's in it. Well, that was the problem over the phone, right? So I said, no, Ray, you're not going to tell me what's in it because you might miss something, or I might misunderstand you, and then we're in trouble. I said, go back to your office and come back, and oh, by the way, bring in another $100. So he goes back to his office, and he comes back, and he gives me $100, and I count it. And then we started talking, and I said, and I was talking about the agreement. I was looking at it, and then I said, well, this, that, and the other thing. And he said, well, no. I sent him an email, and he sent me an email. In actual fact, that's not true. This was prior to email. So I sent him a fax, and he sent me a fax, and I sent him a fax back. And I said, well, let's see the faxes. Oh, I didn't bring them. But I'll tell you what's in them. And I went, no, you're not going to. Go back to your office, come back, and bring another $100. So he did that, and it was like water off a duck's back. He knew he'd made some mistakes, and so he didn't get upset about it. But the whole point is, go to your lawyer, take everything you think the lawyer is going to need, plus a few other things, okay? Try not to use legal terms, and watch the word we. These two things are almost synonymous. I really can't quite figure out the specific difference. But to give you an idea, when I started doing astronomy, there were 3 magazines. There was Sky News Magazine, and there was Sky and Telescope, and there was Astronomy. And so I thought, okay, well, let me look at the Sky News. And I read it, and I go, okay, that's helpful. And then I got the Sky News Magazine out, and I started reading it, and I'm going, because there was so much trade jargon in there, I couldn't understand half of what they were saying. So I started using Sky News until I became more experienced, right? Well, when you're dealing with your lawyer, explain trade jargon. I had a client, 2 guys that started a software company, and they came in and they started telling me what they were doing. And I went, okay, guys, you're talking to a computer illiterate person here. My nickname is Stegosaurus Pete, because I'm actually a dinosaur as far as this is concerned. You have to explain it to me. So you explain trade jargon. You know that. Don't use legal terms, because you might not know their precise meanings. And watch the word we. Elderly couple came in to see me one time, and they said that they were about to retire, and they wanted to make sure that they had no liability as partners in this business. Remember how I said there's potential for partnership liability after dissolving the partnership? So they were very smart. They decided to come in and see the lawyer before they made the mistake. So they're talking to me about their partnership and the business and what it did and everything like that. And I gave them the advice that I thought they needed. And they thanked me very much. And they get up and they're walking out of the office. And they said, and the elderly lady turned to me and she said, so what do I do with my shares? And I said, shares? What shares? And she said, my share certificates in the corporation. I said, what corporation? And she said, well, the corporation that we're partners in. And I went, okay. You're not partners in a corporation. Partnership liability is different. Please come in, sit back down, and I'll tell you how you get out of your corporation without any liability. So they said we are in this, and we means who. So you have to be specific. And they tried to use legal terms that they didn't understand the full meaning of. Okay, so do those things. And then the other thing is never give instructions by telephone. Well, I think that's gone by the boards. Never give instructions by telephone unless you confirm them in writing. I had a very sophisticated client. I think I mentioned the patent on the scrubbing technology for ships to get the carbon out of the atmosphere. This was that client, and he was putting together this corporation to begin manufacturing. And they were having this shareholders dispute, and they were going to have this meeting at 5 o'clock. And so he came into my office, and we were discussing it ahead of time. And he said, and I said, okay, Jim, what I want you to do is I want you to do this and this and this. And he said, okay. And then we talked for a while longer, and then he said, okay, I'll let you know if we need you at the meeting. And he's getting up and he's leaving, and I thought to myself, let's check here. I said, Jim, what is it I told you to do? He looked at me and he said, what? Like, what do you mean? And I said, what did I tell you to do? And he said, well, you told me to do this and this. And there was something else. Okay, so had I left it there and he'd gone out of the office, he might not have done the third thing. I don't know how critical that would have been, but it could have been a danger. So he left the office, and I immediately took out a fact sheet, and I said, Jim, just confirming that you're going to do this, and you're going to do this, and you're going to do this, and if you need me at the meeting, give me a call, sign Peter, and I faxed it through to him. In fact, I did that because I didn't have a phone where you could text. Okay, that was pre-texting. Now I would text him, okay, and then I would save a copy of that. Because if he only does 2 things, 2 years down the road, when he's looking for somebody to sue, he'll say, hey, Peter, you only told me to do 2 things. And I'll say, no, I told you to do 3. He won't lie on this stand in court because he only remembers 2. Okay? So this way I go, no, see, I told you. So, give instructions by the telephone, but then follow it up with a quick text so the person has it in writing. Make referrals is just a way of facilitating business. I have clients come in and I give them the legal advice, and then if some of them need accountants, well, I've got a couple of accountants and I don't recommend one over the other. I say, here's a couple of accountants that aren't the big boys downtown. They're a little more reasonably priced, but they do a really good job. You might want to call one of those. One time I had a client come in and he needed an advertising agency. Well, remember I talked about the advertising client that did all the entrepreneurial stuff. I said, oh, you need an ad agency? Oh, here, maybe talk to these people. I do that because then those clients will say, oh, you need a lawyer? Talk to Peter. And that, facilitates business. In that way, it also means that if I need to talk to my accountant really urgently, and I call him at just, oh man, 12:10, he's going to lunch, right? So I leave a message. Pardon me, my allergies are starting to bother me really badly. He comes back from lunch and there's 5 messages there. One's from me. Who's he going to call first? Me. Okay, so make referrals because it facilitates business. And then the last one is be frank about accounts. What this means is walk in, sit down, look at your lawyer, tell them what you need done and go, how much is this going to cost me? It's going to prevent all sorts of problems later on when you get the bill and you go, wow, I didn't know it was going to be that much. Okay, so you should just do that. I'll post that article to eLearn so that you can read it if you need some further information besides what I've said. That covers a little bit of what's in here. Okay, there's no way we can cover all this, but at least we've talked about the legal considerations, and that's the best that we can do in this course. Okay, so that's stage 6 done. And now it's on to stage 7. Thanks.